So now he has a $10,000, 10% bond with a GPS tether. Sir, your court is directed, you're not to leave the state without permission of the court, you're not to commit any crimes while released. You're to immediately notify the court of change of address or phone number. I've already listed to you all of the victims and have contact with. Last time I arraigned you, you're not to have contact with any T. Simmons, N. Jones, B. Cooper, A. Rushing. You can't go on Leroy Street. And those are the conditions of your bond. You've already been given them once. All right, Mr. Gardner, let me find your file.
It's right on top. Put it right on top.
All right, this is 232375 and 203366, the people versus Eric Gardner.
Now, James Kazicki on behalf of Mr. Gardner, the file from 2020 is going to be dismissed. The victim failed to appear for a settlement conference. And Mr. Gardner, the other one we're going to set for a settlement conference from 2023. You understand what I said?
Say that again.
The one from 2023 is going to be set for a settlement conference for the victim to appear. And the one from 2020 is going to be dismissed. So you just got.
When the court date going to be?
We'll tell you in a sir, let me get through this. Did you understand what your attorney just said?
Yes. I was asking when.
I know, and I was saying we'll get to it, but let me ask you the questions I need to go through with you, and then we'll get to that, okay?
All right.
All right, sir, did you go over your constitutional rights with your attorney?
No, this is not arraignment. I didn't have a chance.
Oh, we're just setting aside the
Yeah.
court, okay. All right, so we're gonna set this other date. So the one case
2020.
3366-203366 is dismissed because the complainant failed to appear. The other case, 232375, we will, I've set aside the warrant. We'll set a settlement conference for the complaining witness to appear. How long are you over in Macomb?
I'm not sure. I should be out of here real soon. I've been in here since June 29th.
Not that I'm aware of.
All
I
right.
believe the court officers checked Zoom and there wasn't anyone.
Nobody? All right, we have, let's see, Taylor High Velocity, 1, 2, 3, 4, 5, 6 civil infractions. Madam Prosecutor.
Good afternoon, Your Honor. Angela Mannering on behalf of the people. Your Honor, today's the date and time for plaintiff's motion for default judgment regarding compliance and cleanup for the property located at 24715 Mary Street. The 6 civil infractions the court referenced are all in default and remain unpaid. We did submit to the court the motion for cleanup. We are seeking to remove the junk vehicles, improperly parked and stored vehicles, as well as the other litter, junk, trash, and debris items on the property. We did provide the court as Exhibit E to our motion an order to that effect, providing that if the property owner does not do that within, I believe, 10 days, that we would handle the cleanup and assess that against the property.
All right, and they received a notice from the court to appear today.
And Your Honor, we also did FedEx that to the residents on Mary Street, and Ordinance Officer Donovan did personally leave a copy at the residence as well.
All right, they failed to appear for today's hearing. I've had an opportunity to review the photographs as well as the city's motion on it. There are so many tickets in default. It's appropriate. At some point, someone has to clean up the property. So I'm signing the order. And is there a period of 10 days you're giving them? They'll receive a copy of this order and they have 10 days to comply before the city comes in, correct?
That's correct, Your Honor. Yeah, once we receive the signed order from the court, we'll have the ordinance department posted on the property, and we will also FedEx another copy to the residents.
Okay. All right, the order's signed.
Perfect. Thank you, Your Honor.
Thank you, counsel.
James Gazicki on behalf of Mrs. Trosky. Your Honor, we're asking for a brief adjournment. I received discovery and not had the opportunity to go through it yet.
All right, Mrs. Frosky, can you tell me your first and last name? You're muted, ma'am.
Okay, sorry, Your Honor. Courtney Ostrowski.
All right, so Mrs. Straussky, you were previously arraigned and given your bond conditions. We will adjourn this so that your attorney has time and an opportunity to review discovery, okay?
Okay, thank you.
All right, you'll receive notice of the new date.
Okay, thanks so much.
Thank you. Emily McGregor, 2520190M.
Good afternoon, Your Honor. James Gazicki on behalf of McGrath. Waive reading of the complaint, stand mute, request a settlement conference, Your Honor.
Ma'am, can you tell me your first and last name?
Emily McGriff.
Ma'am, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, ma'am.
Did you understand your rights?
Yes, ma'am.
And did you give your attorney permission to sign and date that form?
Yes, I did.
Okay. I have entered a not guilty plea for purposes of arraignment. This is a Walmart case, so it's going to end in a dismissal because they don't come to court. So we'll give her $100 personal bond. Mr. McGriff, you don't have to post any money. These are your bond conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. And you're to immediately notify the court of change of address or phone number. Anything else?
No, Your Honor.
All right, you're all set, Ms. McGrath.
Thank you.
We'll send you notice of your next court date in the mail.
Okay,
And I'm
thank
not
you.
even, I'll sign the fingerprint order if necessary at the next date, but I'm not even doing that for Walmart at this point. Ma'am, you'll get notice of your next date in the mail. You're all set.
Okay, thank you.
All right. There we go. This is 2519540M, the people versus Mark Rakoski.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Rakoski. Waive reading of the complaint, stand mute, and request this matter be set for a settlement conference.
All right. Sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, Your Honor.
Did you understand your rights?
Yes, Your Honor.
Did you give your attorney permission to sign your name on that form?
Yes, Your Honor.
All right, I've entered a not guilty plea on your client's behalf. Mr. Rakoski, like, I see you, like, I know your name and I shouldn't.
Yes, I understand.
And it's because you keep getting DVs and then the complaining witness doesn't show up, right?
Yes.
Pattern. So I'm going to give you some bond conditions. You have $1,000 personal bond. That means you don't have to post any money.
All right.
Sir, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. If these are all the same victim, I just alleged victim. This is Brian Lynn. You're not to have any contact with Brian Lynn. You understand me?
Yes, I do, Your Honor.
You can't call him. You can't go to 5940 Dudley.
Yes, Your Honor.
All right, let's talk about that. This hearing in front of Judge Victoria Shackelford had a mix of housekeeping, firm reminders, and just a little bit of levity in between. Judge Shackelford's style came through right away. She's efficient, keeps the calendar moving, but she's also patient enough to make sure each defendant knows exactly what's going on. Even when she had to repeat bond conditions or remind someone about no contact orders, her delivery was clear and calm, strict where it needed to be, but not heavy-handed. It's a good example of a judge balancing authority with accessibility. The case that stood out most was People v's Eric Gardner. Gardner had 2 old cases hanging over him, one from 2020 and one from 2023. The 2020 matter ended up being dismissed because the complainant failed to appear, but the 2023 case was still alive and got set for a settlement conference. Gardner was polite enough, though he did what many defendants do, tried to push ahead and ask, "When's my court date?" before the judge had finished her checklist. Shackelford didn't snap. She just reined him in with a firm, "We'll get to that." It showed her knack for keeping control without escalating the temperature. His attorney, James Patrick, was steady, making sure the record was clean and that Gardner understood what was happening. The next few matters were more routine. We had a civil infraction property case where the city wanted a cleanup order on a lot that had racked up tickets for junk cars and debris. The city prosecutor laid out the problem clearly, even down to how they served notice by FedEx and personal delivery. With nobody from the property showing up, Judge Shackelford signed the cleanup order. Not flashy, but it's a nice look at how courts handle local nuisance issues that affect neighborhoods every day. Then came a string of arraignments with defense counsel waiving readings and asking for time to review discovery. Courtney Ostrowski's lawyer asked for an adjournment, and the judge readily granted it, making sure the defendant understood her bond conditions remained in place. Emily McGregor's case was next. A Walmart matter that Shackelford herself noted almost always ends in dismissal because the company rarely sends anyone to court. McGregor looked nervous, but answered clearly when the judge walked through her rights. Shackelford gave her a personal bond and skipped the fingerprint order altogether, a little signal that the court knows how these cases usually play out. Finally, there was Mark Rakoski. His attorney did the usual arraignment work, but Judge Shackelford didn't miss the pattern. She even commented on recognizing his name because he keeps picking up domestic cases where the complaining witness doesn't show. That little moment of candor was vintage Shackelford. She calls out the elephant in the room, but does it in a way that's matter of fact, not judgmental. She set bond conditions, issued a no-contact order, and made sure Rakoski said out loud that he understood them. His "yes, Your Honor" responses were respectful, though a little flat, like someone who's been through this drill before. The overall atmosphere was steady and orderly. Shackelford moved through a packed docket with efficiency, but she still had time to inject a quick observation or make sure everyone left knowing what to expect. Attorneys on both sides were competent and calm, though it was clear which cases were just passing through the system and which still needed heavy lifting. No one got flustered, and the judge's even tone kept the whole session on track. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.